Hello everyone and welcome you all in this session. Myself, Assistant Professor Ripal Gupta from LJ School of Law. Today I am going to discuss on the subject of legal theory, which means jurisprudence, in which we are going to discuss meaning and definition of jurisprudence. So before moving to our subject, let us understand the concept behind jurisprudence. Jurisprudence is all about legal theory. It is about why we are studying this law, why we have in this legal system, why we are following different kind of legal system. So we have seen there are different legal system prevailing in different countries. Why they follow such system? It is all about jurisprudence. So it is about the science of law. It's about investigation into law. Why we are studying such kind of statute? What is the psychology behind them? What is the philosophy behind the law? That is jurisprudence. So jurisprudence is all about, for example, if there is a mathematical sum, there must be some theory behind it. If there is an invention, there must be some theory behind it. In the same way, in this jurisprudence, from this legal system, there is some legal theory behind it. That is all about jurisprudence. Now let us start with the meaning and definition of jurisprudence. So in jurisprudence, we do not have any specific definition because it is not codified law. Of course, it is a theoretical subject. It's about the theories given by different jurists. So we have the opinion from different jurists on the term of jurisprudence, but let's understand the very general aspect of the definition. So jurisprudence has been derived from a Latin word jurisprudentia, which means knowledge of law. Juris means law and prudential means skill or knowledge. Thus, jurisprudence signifies knowledge of law and its application. So jurisprudence has different names also, like investigation into law, philosophy of law, psychology of law, science of law. So basically jurisprudence is concerned with the fundamental questions of law, justice and legal problems, which include the aspect of philosophical, scientific and historical aspect. So it deals with the different aspects to understand the theory behind the legal system. So first we'll understand the definition given by the John Austin. John Austin is a famous jurist from the jurisprudence. He is termed to be as a father of jurisprudence. According to Austin, jurisprudence is a philosophy of positive law, with law strictly so called. Now what is positive law? Positive law means in any system, if there is a sovereign power, the person who has sovereign power, who has sanctioned power in his hand, he will declare the legal system. So according to him, it is the positive law and it is the jurisprudence or it is a legal system according to him. The person who has power in his hand to make a law and to sanction the same law is a positive school. So according to him, in any system, sovereignty is a positive law and sovereignty is a legal system. So then he divided this system into two parts: general jurisprudence and particular jurisprudence. According to general jurisprudence, it is about the expounder or fundamental principles of the broadest generalization of two or more systems. So it is a very broad system in which any legal system prevail. And second is particular jurisprudence, which is talk about any part study of general jurisprudence. So they both are same thing but different in their scope. They have the same essence, that to study the legal system. But in general, you will study the broadest aspect of legal system, and in specific or in particular, you will study any particular part of general jurisprudence. So this is the definition given by the John Austin. Now we will see the definition given by Thomas Eriksson Holland. Thomas Eriksson Holland defines jurisprudence as the formal science of positive law. Sir Thomas Eriksson has supported the definition given by the John Austin. He just add one word, that is formal science. So he just believe in the external part of legal system. He believe in the external legal system that prevail in any society, but it undermine the internal part of legal system. He undermine the particular jurisprudence and talk about only general jurisprudence, where there is only legal system which are prevailing. So according to him, there is a positive law which is governed by sovereign person who make a system for any country, who sanction the law for the people, but he undermined the internal aspect of the any legal system. So he just undermines the internal part and adores to external part of system, and he talks about is act as a jurisprudence. Now we'll see the definition given by Salman. According to Salman, jurisprudence is a science of law. According to him, what is law? Law is a land, any law of the land. He doesn't support the definition given by John Austin and Holland. There is no positive school of law. According to him, in which system that prevails in any particular time in any country, that is legal system. Be it come from the past or historical time that we are following, but it is a system that we are followed or we are living exists at the time is a legal system. So according to him, there are three parts of jurisprudence. One is systematic, second is generic, third is specific. According to systematic jurisprudence, it deals with the contents of an actual legal system that is existing at a time. So there is no legal system that is propounded by any person. It is this system that we are living, that we are following, be it from past or be it in present. That is the legal system that is accepted by all. Then he divides the system into two parts, generic sense and specific sense. In generic sense, it covers entire legal doctrine of the entire system. That means all the legal statutes, all the procedures that we have followed for that legal system, it is in a generic sense. Specific sense deals with any particular part of generic sense, that study of any particular process or any law, that is specific sense. So he defines jurisprudence into three parts, systematic, generic and specific. Generic and specific are part of systematic jurisprudence. So according to him, the system in which we are living is a jurisprudence. So in this session we have seen or we have studied the concept of jurisprudence, the different definition given by the different jurists. We have studied the definition given by John Austin, who followed the positive school of law. According to him, there is a sovereign power who makes the law for them, and it is not a goodness or badness deal with the law. Second is Thomas Eriksson, Holland, which supported the definition of given by John Austin. He just add the word formal science and undermine the internal part of any system. And third is Salman's definition, which given a different aspect from both of them, and he said in legal system which we are living is a jurisprudence. So this all about the definition part and meaning of jurisprudence. Thank you.